Ryan Goodman just found this. Section 298. Consequently, the court finds that petitioners have established that Trump engaged in an insurrection on January 6, 2021 through incitement, and that the First Amendment does not protect Trump's speech. Secretary, how significant is that line for you? I mean, it is, to me, pretty stunning here. Their whole concern had been, oh, well, insurrection and sedition conspiracy are hard to prove. The judge says in this ruling that they did establish that Trump engaged in an insurrection.
It's really powerful for the entire nation. I believe Trump incited insurrection. There's always questions whether his incitement reached the level of disqualification. And to find a court of law determine that, yes, he did incite the insurrection, I think is important for the entire country. Regardless if Trump is on the ballot or not, he is a danger to American democracy.
Judge Sarah Wallace ruled that Donald Trump, quote, engaged in an insurrection on January 6, 2021 through incitement, and that the First Amendment does not protect Trump's speech. However, in the same ruling, she found that the 14th Amendment's insurrection ban does not apply to presidents and therefore rejected the effort to remove Trump from the primary ballot in Colorado. Here's what Section 3 of the 14th Amendment says, quote, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. Judge Wallace therefore went on to write, after considering the argument on both sides, the court is persuaded that officers of the United States did not include the President of the United States. It appears to the court that for whatever reason, the drafters of Section 3 did not intend to include a person who had only taken the presidential oath. And look, I'm not a constitutional scholar, nor do I claim to be, but the notion that the founders made the conscious decision to exclude the President of the United States from the insurrection clause is absurd on its face. Of course, if you don't want to take my word for it, you can defer to an actual constitutional scholar. Judge Luttig, one of the country's preeminent conservative constitutional scholars, wrote, quote, it is unfathomable as a matter of constitutional interpretation that the presidency of the United States is not an office under the United States. It is even more constitutionally unfathomable, if that's possible, that the former president did not take an oath to support the Constitution of the United States within the meaning of Section 3 when he took the presidential oath to preserve, protect, and defend the Constitution of the United States. The Constitution is not a suicide pact with America's democracy. Indeed, it is the very contrary in this instance. It is plain that the entire purpose of Section 3, confirmed by its literal text, is to disqualify any person who, having taken an oath to support the Constitution, engages in an insurrection or rebellion against the Constitution. The former president did exactly that when he attempted to overturn the 2020 election and remain in office in rebellious violation of the Constitution's executive vesting clause, which prescribes the 4-year term of the presidency.
Well, Section 3 of the 14th Amendment provides an automatic disqualification for running not just for president, but any federal office or any state office if you've been an office holder before who has sworn an oath to support the Constitution, and then you violate that oath by engaging in insurrection or rebellion against the Union. And if you do that, you're immediately disqualified for.
But it's never been tested. Am I correct? It's never been tested.
Well, no, I mean, it actually operated after the Civil War. It was put into the Constitution by the Republican Party after the Civil War in order to disqualify people. When the House actually first voted on it, they said they were going to disenfranchise anybody who'd participated in the Confederacy. And when it got over to the Senate, they said that sweeps too broadly. We just want to focus on the worst offenders, people who were actually in office, who swore an oath to uphold the Constitution and then violated it. And even in those cases, we're not going to disenfranchise them and say they can't vote ever again. We're just going to say that they can never hold office again.
Does it almost not matter what the outcome is in this case in Colorado, since it's becoming more and more clear that the Supreme Court will be the final arbiter of this decision?
You know, it matters. Here's why it matters. Because the Supreme Court will have to look at the evidentiary record that was developed during the course of the suit. And that's why I think it's important that Crew is bringing a very strong evidentiary case. They're going to put on lots of witnesses. They're going to develop the factual record. And then it is that factual record that will be handed off to the appellate court, first the appellate courts in Colorado, but then ultimately it will jump into the federal jurisdiction, and it will be decided by the Supreme Court. So I suspect what's going to happen, Brian, is lots and lots of states will have legal challenges brought to whatever it is they decide. If a Secretary of State, for example, decides to put Donald Trump's name on the presidential ballot, then there will be legal challenges brought saying, listen, the Constitution says somebody who engages in insurrection is constitutionally disqualified, so his name can't be on the ballot. So a suit will be brought to challenge that decision. If the Secretary of State opts to leave Donald Trump's name off the ballot, then suits will be filed saying, hey, that's election interference. His name should be on the ballot because there really is no showing that he engaged in or gave aid and comfort to the insurrection. So you're going to have lots of legal challenges brought, I think, regardless of which way each state goes with respect to putting on or leaving off Donald Trump's name.
And of course,